This is a very interesting and dynamic panel about data protection and trade, and should personal data transfers to third countries be included in trade agreements. I want to introduce our chair, which is Jan Albrecht, member of the European Parliament. He scarcely needs a long introduction, but very significantly for this panel, he has been the rapporteur in the Justice and Civil Liberties Committee on both the trade agreement between the EU and the US called TTIP for short, and more recently on the Trade in Services Agreement, which is an agreement between 22 countries. So, Jan, you have the word.
Thank you very much, Anna, and welcome and good morning also from my side. I think that with this panel, we really have an interesting talk in front of us with very well-known and interesting people and speakers here. And my impression with regard to the rules on data flows in trade agreements until today is that there are very different approaches, but there is a general standard in the GATS agreement, which is calling for the fact that normally each and every party should be allowed to do the protection of personal data in the form also of a fundamental right, while not hampering, or that this would not be hampering trade. I really think that this is something which we now in the future will see to be a very important part for the European Parliament to insist on, which we did in the recent decisions on TTIP, and now there will be also a plenary resolution on the TiSA negotiations. The opinion or the report of the European Parliament on the TTIP negotiations showed clearly that in this area the Parliament stands with a large majority on the position that in these negotiations there should be no limitation to the possibility for the European Union to set its rules on the protection of personal data, which derives from the clear fact that this is a fundamental right in EU law, and that it's not also up to the legislator to just put this for negotiation in trade agreements. It would just be not in line with the treaty and with the Fundamental Rights Charter. And therefore also I think that the decision of the European Parliament is a clear red line to the Commission when negotiating the TTIP agreement, and an indication that if there would be any limitation to European Union's data protection rules, especially now where we did also our new framework with the General Data Protection Regulation, this would not be a trade agreement which would be voted by majority in the European Parliament. And that is needed because the European Parliament is always to be giving consent to international agreements, in particular trade agreements negotiated after the Lisbon Treaty. And the International Trade Committee in the European Parliament with its rapporteur Viviane Reding already voted on their text, and that will be put to plenary on the TiSA agreement, the Trade and Services Agreement, and there we will have the essentially same line voted as we have in the report of the European Parliament on the TTIP negotiations. So it's a very clear line, and I think that this is something which therefore also will have to be respected very clearly by the Commission and in these negotiations. And it's also in line with the trade law and the WTO provisions which we have in place today. We will hear about that later on. Therefore, I really think that we have to not only talk about the question in how far we deal with the laws on personal data and provisions on personal data in the area of trade negotiations, but also talk about even more about agreements which positively formulate the standard for the protection of personal data on the basis of our legal principles, which have been underlined just recently with the European Court of Justice judgment on the Safe Harbor case, where it's clear that there need to be standards which are essentially equivalent to what the protection in the European Union is if you really want to allow for a comprehensive sharing and transfer of personal data from the European Union to other parts of the world. I would like to add finally that I don't believe in the fact that having safeguards and standards also in the area of international trade for personal data will hamper the possibilities for trade, because it's clear that here we talk about an area where I think trade is dependent also on the trust of consumers and the trust of citizens in the application of some standards. And we rather work on improving the standards and having high standards across a global regulated market than having a race to the bottom or forum shopping. That's exactly what we as Europeans did try to get away from inside our own markets, and that is what will be also the position of the European Union with regard to international standards and debates which we are having right now. Thank you very much, and with these words I give back to the moderator of this panel, Anna Fiedler from Privacy International.
Thank you very much, Ian, and you've put a lot of issues on the table that we need to discuss. Before we start, can I ask you in the audience to raise your hands if you are familiar with trade issues, because that's what this panel is about. Okay, so there's quite a lot of knowledge there, but about half the audience is not familiar with it. So, as you know, this panel, as is in the description says, it's essentially about the increasing tendency to add data flows or transfers of personal data language in trade agreements. And the key question is, does that hamper proper development of national and regional data protection laws or not? So we have a fantastic expert panel. I'm not going to introduce them at length because you've got their full CVs in your programs, but very briefly, starting, and if I pronounce your names wrong, please correct me. Burcu Kilic is the legal counsel at Public Citizen in the United States, which is a consumer and citizen advocacy group. We've got Kerry, who again scarcely needs introduction, but he is currently senior counsel at Sidley Austin and distinguished visiting fellow at Brookings, and he's former acting secretary of the US Department of Commerce. But very significantly, he's written extensively on this subject, including related subjects. About 2 days ago, you launched a report. Joe Alhadeff, who is, I sort of call Joe the global policy voice of business. He works for the Oracle Corporation, but he also represents business in OECD and many other international fora. We have Rupert Schlegelmilch, who is, you've got a very, very long title, but essentially he's the boss of the services department at DG Trade, so he basically is responsible for all these negotiations. Is that correct? So very important person as well. And last but no least is Kristina Irion, who is a Marie Curie Fellow at the Institute of Information Law at the University of Amsterdam. And Kristina, can I start with you?
Yeah. Good morning. Can I have my slide, please? So I would like to give you a very, very brief introduction to the GATS and the WTO dispute settlement system in relation to safeguarding EU standards on privacy and data protection. And this will provide you with the necessary background to follow then the discussion in this panel on bilateral trade agreements and investment treaties such as CETA and TTIP, which is presently under negotiation, and also the negotiations on the multilateral agreement TiSA, which is meant to replace the GATS in the future if it succeeds. So WTO law comprises of several international trade agreements, and we are focusing now on the acquis of the General Agreement in Trade and Services, the so-called GATS. This agreement provides for general obligations and notably here the most favored nation treatment, and there are also sector-specific commitments. These commitments are defined in a national schedule of specific commitments, and here then the members can commit to provide treatment of domestic regulation, market access, and national treatment to specific service sectors, for example, e-commerce. The GATS has also in the general body an exemption in Article 14, which includes a specific mentioning of the protection of the privacy of individuals in relation to the processing and dissemination of personal data. And the text of this article you see displayed on the slide. In order to rely on these general exemptions of Article 14 of the GATS, this has to pass a two-tiered test. And I'm going to walk you very quickly through the test. There has to be a legitimate aim, and we are lucky that privacy and data protection, wait, it's not working. Yeah, the protection of privacy of individuals in relation to the processing and dissemination of personal data is specifically enumerated. This has to be necessary and pass the necessity test, which consists of a weighting and balancing also of various alternatives that would be less trade restrictive. And then overall this measure that is contested and tries to be justified under this exemption has to be justified under the chapeau, which is the top provision. And this chapeau actually consists of three cumulative criteria that have to be read, that if countries have similar conditions that are comparative, then there should be, this measure should not arbitrarily discriminate or unjustifiably discriminate. And the final relevant context here, that it should also not operate as a disguised restriction to trade in services. So both the necessity test and the chapeau can be applied to limit the restriction of a measure with international commerce. And the burden of proof is on the respondent, so that is the member state that is actually invoking this exception. And if we now look at how the WTO dispute settlement works, at the moment this is a state-to-state dispute settlement procedure. The WTO has an exclusive and compulsory jurisdiction, so disputes under this agreement have to be brought to these bodies. And it also builds up its own set of precedents, so it starts to be developed slowly into an own sector of law with precedents how certain tests or certain elements of the treaty is to be interpreted. So we have, for example, some precedents on the necessity test. And there are also several procedural rules which could subtly operate in favor of international trade interest. Already the burden of proof is one of these. Yeah? So what does that mean for safeguarding EU standards on privacy and data protection? First of all, there's a lot of uncertainty right now as to the actual capacity of this GATS Article 14 to exempt the entire EU acquis on data protection, right? There's presently no precedent in WTO dispute settlement on the protection of privacy and data protection. So we don't know, for example, how certain elements of this GATS Article 14 relating to the word privacy, to the word in relation to the processing and dissemination of personal data, how this would be interpreted. We should not simply assume that our notion in the EU of personal data or of what processing means is adopted. Yeah, there is not such a rule. And it is also not clear how specific commitments in certain sectors and the general exception would relate to each other if these commitments have been entered into as unconditional. There are also known legal risks that I tried to tell you how for a party to rely on the general exception, for example, the necessity test, and also this chapeau, the upper part, can actually become sort of unpredictable. And WTO dispute settlement is also not bound by EU law. So overall, we have to, we enter legal uncharted area here, but it is the next frontier of international trade law to handle data protection and international transfers of personal data. Thank you.
Thank you very much, Kristina. So more fun for the lawyers ahead. You know the Shakespeare Henry VI quote, he says, the next thing we should do is kill all the lawyers. Right, so I would like the panel to answer this basic question very, very briefly, is why do we need in trade agreements a provision on data flows or data transfer language when we've got perfectly good international agreements such as the OECD guidelines or Convention 108? What does trade add to that? Could we please start with Cam, please?
Thank you, Anna. Well, let me look at it broadly, and I think Joe Alhadeff will get into sort of more of the particulars of what it accomplishes. But the program talks about the flows of digital information as part of the mainstay of the economy today. Commissioner IViR-UvA, following the Safe Harbor decision, talked about the flow of data across the Atlantic as the lifeblood of the European economy. My colleague at the Brookings Institution, Josh Meltzer, has done excellent work in documenting the value of the flows of digitally enabled trade. And for the United States, that amounts to 384 billion in exports, 234 billion in imports. For the EU, those numbers are 465 billion in exports and 297 in imports. So, you know, a couple of things are clear from that. One is that the EU has a huge stake in these issues, and that a lot of that flow of both exports and imports is with countries other than the United States. So it is important in broad terms to maintain the value of the flow of information as an essential instrument of the trade that those agreements are trying to sustain and to grow. And to include provisions that deal, for example, with data localization is to prevent fractionalization of a network that provides global network effects. And it's clear as well that in this context, when it comes to an issue like data localization, that the focus tends to be looking at this in terms of the United States and all of the issues that roil around transatlantic data flows. But the EU has important offensive interests there as well. When Russia adopts data localization laws, that has an impact on EU countries. These provisions have impact on China, which is a party to TiSA, to give just a couple of examples. So let me address sort of briefly with a story the notion that having these provisions in TTIP or TiSA is somehow a Trojan horse to undermine European EU data protection. So when TTIP was being scoped, when the EU was dealing with the mandate, when the United States was trying to figure out its negotiating positions, I was leading the interactions with the EU on data protection issues and data flows, and certainly considered, should we try to deal with some of these issues in the context of TTIP? And it very quickly became clear to me that that was really a non-starter, that was going to be too hard to do in that context, and if for no other reason, then we could never get it through the European Parliament. So while we thought about sort of using that as an offensive issue, very quickly the position became sort of status quo. Now, post-Snowden, the EU started to say, well, maybe we should try to get data protections into a TTIP agreement. And that reverted to the status quo that data protection as such is not going to be part of these agreements. That was the EU position. And that, I think, is the basis going forward. That does not exclude having provisions affirming the value of the flow of information, opposing data localizations. But given the Article 14 provisions, which I think one can assume would be in an agreement like that in some form, that preserves the exception for data protection.
Thank you very much, Cam. So that's clear. It's the economy and it's the wider global implications. Rupert, please, can I ask you to answer this question, but also maybe respond briefly to what Cam said?
Yes, thank you. We, from the trade side, I think we are the first to admit that this relationship between the policy objectives of data protection, privacy protection, and the free flow of goods and services across the planet, that tension needs to be solved. And I think my first very clear statement is, in the EU, we've decided to solve it in a way which makes very clear that you cannot use a trade agreement to regulate data privacy or protection. And the rules that have been quoted from the GATS or from the GATT actually do make this clear. The real question is, where is the borderline between a very clear hierarchy of norms, you can do this, and the question of abuse? And this is, I think, the one thing that we are grappling in the fine print of our negotiations. Let me give you an example. And I don't have to echo the words how important all of this for modern data mining, financial services, and so on. Without data flows, none of this would actually work. The situation in a country like Russia, which has been mentioned, where there is a blunt prohibition coming up now to transfer any personal data, makes it impossible for airlines to do bookings without putting the service into Russia. They make it impossible even to have some of the social media working properly, and there are a number of other, of course, clearly business cross-border e-commerce applications which will not necessarily work without a major disruption. On the other hand, the justification for that is the protection of the privacy of Russian consumers. Another example, in another country in Asia, the banking law said for any individual transaction with a foreign bank, you need to sign a data protection waiver. Not just that you have your account being dealt with, but for every transaction, every time you withdraw money or you do a transaction. That is another question, and the reason was data privacy should be should be respected, and this is why these things should happen. So the real question is not, does data privacy trump trade, which it should, because for us it's a fundamental right. The real question, how do you deal with these borderline cases when you have to think about, is this still a legitimate policy issue or not? And that is, I think, the discussion which will take place. And just to give you an example, this is not very new to trade. Look at maybe a very easy to understand example, agricultural trade. you can trade your agricultural products, but you have your health rules, and if the stuff is not safe, you cannot trade it. It's the same distinction, and then of course the question, what is safe? And we can have arguments about what is safe. The bottom line for us is, and that I agree with Cam, that we will not in any trade agreement try to define what the right standard, etc., of these things in data protection is. Data law is evolving. We have new legislation on our data regulation, the basic regulation. We will have new issues coming up, and finally we solve some of the other issues like safe harbor. So the second main point is these references have to be dynamic. It means if our level of protection in data will change, that's not a reason to attack it under a trade law. The basic rule has to make clear that the level of protection in these things is up to the EU or the US or any third country to do. And again, then of course, again, you come to the question what to do with abuse, and the examples that Kristina has quoted, that you have to look at the trade restriction, etc., that will be the conundrum to solve, whether there is a scope here to argue about these issues. I think I'll stop here, but this is our basic approach on this issue.
Thank you very much. That's very clear, and it sort of complements the picture. Joe, business views on this, please.
Thank you. I'll actually go back to the initial question, perhaps, and suggest that if you look at the OECD, the Council of Europe, even 9546, they're privacy instruments that have within them the concept of safeguarding data flows that are not contrary to privacy interests. Trade agreements are in many ways the opposite side of the coin, which are agreements that safeguard the trade. It used to be in goods, and then it was in services, now it's also in data, while still preserving privacy and security as the nominated exceptions, but there would be others that could fall into that. So one, I do think the trade agreements are necessary because it's the phrasing in trade language that is important. Why it's important, some of the examples have already been given. I would suggest that perhaps the first example is not on the border. The first example is way over the border and would more likely be into the disguised trace barrier sense of the neighborhood. But there are 6 or 7 countries that have been passing laws, and this is outside of the transatlantic relationship. 6 or 7 countries that have been passing laws that require indigenous innovation, local production, local servers, local data centers, local employment, local copies of data to be maintained, all of which are done not for a reason that would meet the underlying exception requirements, but rather because there is a need in that region for further employment, there is a desire to become a tech hub, there are all sorts of things which in a trade sense you would want to do by the correct incentives, not by this kind of backhanded, you must be in my neighborhood and I'm going to justify it by using the words privacy or using the word security, but not associating them with the concept of a fundamental right or the other concepts which are the basis of where you would find the exceptions. And even when you do use an exception that's predicated on the right, and this is where we get to the issue you raised, you get to the, how many angels are dancing on the head of a pin question, which is how do you actually interpret then the, is it more restrictive than necessary and some of the other things? And there's not a tremendous amount of jurisprudence related to those issues. So they will be issues that can be touchy, and there's a reason why there are sensitivities around these issues. But in those countries that I mentioned, they equally impact European companies, and I do a lot of work across international trade associations. And when we have delegations, it's not just Americans showing up on those delegations, it's Europeans, it's Japanese. They're all going into those areas saying, essentially, if you make us put a data center in every country, you can just say goodbye to cloud. Because the whole concept of the economies of scope and scale go away. And so these are the kinds of issues we're trying to deal with, and we're not trying to minimize the sensitivity of the solutions to those issues, nor the fact that in some places we're in slightly uncharted territory and we need to be patient with each other as we discuss these things in a constructive fashion. But there are clear and legitimate reasons why it is important to address these issues, because unfortunately that localization and indigenous innovation concept is unfortunately a growing trend, not an isolated one.
Thank you very much. That's very clear. Burcu, can I come to you? The message that has come out so far, particularly from our US colleagues, is that you need to safeguard data transfer while preserving privacy and security, and the examples that were given is mostly outside the EU and US. You have experience with that. Please, can you tell us?
Okay. It really amazes me how much Europeans love GATS 14. So I'm going to talk about GATS 14. Can we get this slide back? Because we had the same discussion during the Trans-Pacific Partnership Agreement negotiations, and I was talking to the negotiators there. Like I was like, guys, like this is about privacy and this is about data protection, and they were like, don't worry, there is GATS 14 there, and we will come up with the same kind of exception. And the TPP exception is very similar to this. They reframe the exception, but they have it. So the TPP is the first free trade agreement with a direct obligation for cross-border data transfers. I want to say cross-border data transfers because we are talking about trade. At the end of the day, I'm a trade lawyer, so I want to use the trade terminology. So GATS 14. You know, GATS 14 is very similar to general exception of GATT, General Agreement on Trade and Tariffs, GATS 20. And GATS 14 and GATT 20 has been, they have been both used and many times. And actually countries tried to use these exceptions many times. Every time they came up with public interest promoting policy measures. So interestingly, it always failed. There were 44 cases in the WTO related to these exceptions, and it failed 43 times. So we are talking about an exception which didn't work for environment, for other public policy measures. And we are not sure whether it will work for privacy. So, and the discussion in the TPP was like, as I told you, TPP is the first free trade agreement with a direct obligation for cross-border data transfers, which is WTO plus obligation. So, and in the TPP, negotiators came up with an exception which is very similar to this exception, which has many layers. Which has many layers, and so lots of tests you need to pass, because when you read the legitimate public policy measure, yeah, privacy is a legitimate public policy measure, not necessarily, you know. So the trade bodies like the dispute board or the arbitrators will decide, and so it's quite questionable to use this exception, which is a WTO exception for WTO plus obligations. And since free trade agreements are taking place behind closed doors, we can't really comment. We can't really work on the exception. I mean, we know the technology and we understand that cross-border data transfer is needed for the businesses and for the technology, but we can't really rely on an exception which never works. You know, there were only one case which the exception worked in WTO, and plus these free trade agreements, they come with ISDS. So how can we expect like the arbitrators to interpret this positively for privacy, data protection, or any other public policy measure which is legitimate for you, for me, but not necessarily arbitrators. So it's like we are taking a risk. And if we are going to have this discussion, we have to have this discussion here. We need to discuss, you know, what kind of exception we can come up with. How can we improve this language? Because we know that this is not working.
Thank you very much. That's very clear. So from what I understand from the very interesting discussion so far, what it boils down to is that nobody's denying that we need some kind of format for effective data transfers between countries, But the key is how do you use the language and the exceptions to make sure that that doesn't impact on fundamental rights and data protection. And you heard Burcu saying that, you know, the GATS exception has been used in lots of other public legislation and policy according to the public citizen research. It hasn't worked in other domains. Why should it work on that? So who wants to comment first on this issue? Yeah.
I would say that in the experience we've seen with both the privacy and the security exception, there is actually great reluctance from any country to have any other country trigger that specific exception. And in fact, the fear of that exception being used, because in some ways it becomes a nuclear option, has actually led to compromises that otherwise wouldn't have been made. So I don't know that it's fair to say that this exception doesn't work. It hasn't been tested, yes, but the emanations of this exception have already led to compromises. So this exception does have teeth. How it will be used, and I think the place where the confusion will be, I don't think anyone would question the concept of the fundamental right to privacy being sufficient to meet the exception. The question is the current implementation of that sufficient to meet the exception? Because as we heard, the Russian kind of concept of prohibition, which is being justified by privacy, is not by any means the least restrictive way of accomplishing that end. Mm-hmm. And I think there is a concern that you may lose the fundamental right in the nature of the debate over the elements of the exception. And that's where the lack of a jurisprudence, I think, is creating the concern. And that's something where I think we need to have a broader conversation to figure out how to get a comfort level around those concepts. But I don't think the concept would be to challenge the fundamental right of privacy, but rather a specific implementation of it.
Okay, thank you. So, Kristina, basically, the exception works because nobody has had the courage to challenge it in the privacy sphere. How do you respond to that?
I have two issues I would like to raise. The first one is this narrative around this Russian data localization laws. I mean, I'm speaking for the EU, but there's clearly a different background to this whole, and we shouldn't conflate cause and consequence. I mean, one reason why the safe harbor collapsed was that the entire assessment of the EU legal system on the protection of personal data has failed in the field of national security, and that's why we are without a safe harbor right now. And also this narrative around cloud computing, I cannot completely understand, because actually cloud computing could also be a solution, right? And not just be threatened by data protection rules that sometimes result into keeping data on the territory of, for example, the European Union. Secondly, the international trade law is not embedded in a fundamental rights system. We have seen what happened in the EU once the EU Charter of Fundamental Rights entered into force, and how our highest European court, the ACJ, actually rose from a market integration court into a fundamental rights protection court. And this is something that could only happen because there is the Charter and because fundamental rights are now an element of our primary EU legal order. How can some emancipation, so to speak, take place in a different, separate legal system and jurisdiction where fundamental rights are actually only annexed to the main interest of international commerce? So this is basically what I wanted to hit here.
Thank you. Rupert, can I ask you to comment on that? Because I know that your mandate is no data protection, but yes to data flows, and I never understood how the two reconciles themselves. But Kristina's specific point is that the WTO court doesn't deal in fundamental rights, the European court does.
Well, I think the answer to that is that we haven't written the latest rules on this issue yet first. If you look at the TPP, there is a recognition of data privacy, maybe not as a fundamental right, but it says something about this. So that's maybe an inspiring way to go at the issue as well, to rebalance what some of you might see as an unbalanced situation. I would not take issue with the fact that trade, there's no fundamental right to trade. Yes, but there are lots of fundamental rights which come into play when you look at the trading system. We have a huge debate about human rights and trade. Should we trade with countries that do human rights violations, to take the most extreme example? I think what we are doing is to make sure that we don't step on the toes in our world on these issues in any way. And the way to do it so far, you have mentioned that, many of you have mentioned that, is to, at least in the GATS, there is nothing on trade flows. In the financial services understanding, to make life a little bit more complicated, but the experts know what I'm talking about. It's not the TPP who has invented this, it's actually in the understanding on financial services in the GATS, where there's already a clear recognition that transfer of financial data should be allowed subject to data privacy. So that equation comes a little bit from there. Nothing would stop a legislator to say, do what the EU is doing. You don't have a right to transfer data outside of the country unless there is the protection guarantee. That's the way our basic law functions, and the new regulation, as far as I understand it, will not change that basic concept. So there are policy choices here which we will have to make, but in the end it will all boil down again to the reconciliation, because even if you have a basic right which says you cannot do it unless there is safe harbor or something else, in the end you then have to look whether this arrangement functions and safeguards fundamental rights the way the exception would also have to look at that. So in the end, I think the consequences of all of this is we better draft these rules, maybe a bit more sophisticated than Article GATS 14. We better draft these rules to do the best legal fix to reconcile the issue in case there is a conflict. There hasn't been one, true, but if you look at the GATT jurisprudence on environment, where there's also a general exception for protection of the environment, although it's phrased slightly differently. There have been quite a number of cases which teach you a few lessons on how panels have looked at these issues.
So we need to be more sophisticated in how we address these exceptions, which essentially it's a convergence with what Jan and the European Parliament resolutions say, a general exception, yes? Cam, can I ask you to comment on this, because Rupert also mentioned the safe harbour issue. Can you comment a little bit on, from your perspective, the impact of the safe harbour judgment very briefly, and I'll ask Burcu to have some comments on that, and then I'll throw it to the audience. Are there microphones for the audience? Yeah? Okay. Yeah.
Sure, thank you, Anna. So I'm here I guess on this panel in my capacity as a fellow at the Brookings Institution, but as Anna mentioned, I'm also at the Sidley Austin law firm, and we put out a report this week that looks at some of these issues in terms of the meaning and the application of the safe harbor decision. And I think particularly the view that the discussion begins and ends with the EU Charter, and that therefore it's not necessary to take into account the laws of the member states. And I think what the analysis shows is that both EU law and international law require that the application of that decision take into account the laws of the member states. And by international law, I mean trade law obligations, GATS and GATT. And very simply, the obligations of national treatment to treat third countries the same as EU member states, and the obligation of most favored nation to treat third countries alike. And so that failing to apply to the United States, in particular, the same standards that apply under Court of Human Rights jurisprudence to the member states, the same latitude to balance fundamental rights and safeguards could violate national treatment. And similarly, failure to apply the same adequacy standards to the United States as to other third countries could violate national treatment. And I think those issues are down the road, but I think looming if if the Article 29 Working Party were to take action with respect to model clauses or to binding corporate rules aimed exclusively at transfers to the United States under those rules, then I think we have a trade issue, because those clauses are used to transfer, are used by European companies to transfer to a great many countries around the world. To pick a few trading partners, significant trading partners of the European Union: China, India, Russia, all countries that have very strong and pervasive national security surveillance. So if those, if model clauses and other binding contracts are suspect for transfers to the United States, then they are suspect for transfers to a great many countries around the world.
Thank you very much for that. Essentially, I understand what you are saying is that the impact of the safe harbor decision, in effect, can have down the road a legal challenge of a barrier to trade to the United States.
That is potentially the case. I mean, the GATT's Article 14 allows for data protection, and that's. But the question is the regulation discriminatory? Is it applied in a way that is discriminatory?
Yeah, no, that's really clear. I see Jan and Burcu are dying to comment, so Jan, you have the privilege of the chair.
Okay, I just would like to comment on that, because I think that the case of the safe harbor judgment is, of course, not only to be looked at in with the eyes of different treatment, but of different jurisdictions also. It's not in the jurisdiction of the European Court of Justice to decide on the member states' national security laws, which I very much regret, which I think is a task for European politicians to show that they treat their friends and allies the same way than they treat their own member countries. But it's not arbitrary jurisprudence by the court, because the court decides on the rules which apply to the European market, and those are, I think, without any discrimination. And of course, if there would be a case coming up, for example, on some data transfers to other states, there could be similar indications given, although, for example, countries you named like China obviously don't have an adequacy rating. I mean, that's a very huge difference. And then also on the trade laws, I think that it could not be justified to say that a requirement for data transfers is a violation to trade laws. I don't think that a requirement to data transfers when it is about personal data, and that is exactly what is mentioned in GATS, would be completely covered by this exception. And that is why I also think that this exception is a watertight one. I would agree that, of course, it leads more to soft litigation yet, but if it would be for a hard decision, I don't think it would prevail that you could say a precondition for transfer, like formulated as a fundamental right, would be an infringement to that. That could not be justified.
Okay, thank you very much. I know Burcu needs a chance to comment, and I really want to involve the audience. So
Okay.
I know everybody's burning to continue this discussion, but if you get your questions ready after her intervention, and then we can continue the discussion with the audience, yeah?
Okay, I'm really enjoying this discussion because there was a hearing recently at the U.S. Congress about safe harbor. And the U.S. industry was not happy with the safe harbor decision, and they were like, they were discussing whether U.S. should take the EU to the WTO dispute resolution, and then we can see whether this exception works or not. But the key discussion, the key point here is like after the safe harbor, it became clear that like there are. These issues are shouldn't be considered as like the trade issue, as a trade issue, because it has other implications for fundamental rights and liberties and everything. And but I'm so sorry to say that, but the very existence of privacy rules is non-tariff barrier for trade. So it's like if we look from the trade perspective, yes. The privacy rules is a non-tariff barrier, and this is how the United States Trade Representative sees the data protection laws or the privacy rules. So that's why I'm really enjoying this discussion, and I wanted to raise the issue. Yeah, we are not sure even now whether GATS 14 will work. And we are coming up with a WTO plus obligation. There will be a rule in TTIP for the cross-border data transfers. And then we will rely on the same exception?
Okay. Very brief, because we really need to involve the audience. Yeah.
I just would like to clarify in response to what Jan said. I am not saying that that the CJEU decision in and of itself is discriminatory. It's a question of how it is applied going forward. And the Commission itself has recognized that the question of how the directive and how data protection regulation is applied is a potential trade issue. When this initial safe harbor decision was entered into, the Article 31 committee said that directive enforcement should be impartial, both as between different third countries and between different third countries and EU countries. And that's reflected in a reservation that is in every adequacy decision that the Commission issues. And I think that is precisely my point in how this gets applied going forward.
Thank you very much. Okay. If you have any questions to raise on the issues discussed or any new issues to bring in, your turn is now. Okay, Max, we've got the safe harbor decision here, right?
Yeah, I had a couple of questions to Mr. Kerry. I read the 188 pages, and or at least I tried to read it. It was a hard time. I'm wondering if you really think anyone does. And I thought it was really interesting what Jan said, because pretty much what all these papers that are coming out of the US, which is basically concert, we all know Facebook is putting out the same arguments as you do, Peter Swire did. And you're absolutely missing exactly these two different jurisdictions. We have wrong countries in the European Union, like the UK, that does a lot of mass surveillance, but the European Union doesn't have any jurisdiction over it. So I wonder, coming from a country that is federal, like the US, if you don't understand the difference between member states and the European Union, because basically the argument you're bringing up is, we look at the worst country in the European Union, and we say, oh, we're essentially equivalent to the UK, so everything is fine. That's not a price you want to win anyways, but I think the other thing is that you also have to meet Article 8 of the European Convention of the Charter, which apparently US law doesn't. And I wonder if you could elaborate on that a little bit. The other thing on what you said on really enforcing these things, There is an exception in the standard contractual clauses, Article 4 of it, which says that if a country has law that violates the standard contractual clauses, you cannot rely on them. And this will be used against China and Russia as well. The problem is that the US is the dominant market, in the dominant market position. I'm not using any Chinese services, so that I think the cases are going to come down against the US, but not because everybody hates the US that bad, but because you're kind of the dominant market positions. I wonder if you could elaborate on that.
Sure, well, thank you. And as Max mentioned, it is a long report, but you can find it at datamatters.sidley.com. I commend it to you. So the analysis, yes, the EU does not have jurisdiction with respect to the member states. Article 6 of the Charter makes the protection of security and safety also a fundamental right and assigns that responsibility to the member states. But the jurisprudence of the Court of Human Rights is something that is taken into account by the CJEU. And that jurisprudence gives to the member states a margin of discretion in how they apply the principles of necessity and proportionality, which do apply to all of the member states. And that's fundamentally what's at issue in the Safe Harbor decision. And the Safe Harbor decision goes through a set of safeguards for fundamental rights that's similar to the safeguards the Court of Human Rights applies. But there's some significant, those safeguards are a menu. And the range of discretion is affected by the range of practices, the range of application among the member states. So what exactly applies is in part a function of what the member states do. And yes, I agree with Jan that there's work to be done in the European Union to get your house in order with respect to surveillance, as I think we have further work to do in the United States. But in the meantime, don't apply one standard to the United States and a different one to the European Union. That discussion is something that needs to move in conjunction across the Atlantic and around the world.
Okay, thank you. Following on that point, one standard to the rest of the world, a different one to the US. You wanted to comment, Kristina?
I would like to just give, like in a nutshell, my reading again of the Safe Harbor decision. In fact, what the ACJ was doing is barring a sectoral solution in order to facilitate data flows, but always requiring that the assessment, the adequacy assessment, is made taking into account the whole legal system of the state that has to be assessed. And this is essentially why the Safe Harbor, which was only on the commercial exchange of personal data, failed. Although maybe under a WTO reading of the whole issue, sectoral solutions may be deemed perfectly adequate. Yeah? But our highest court in the EU says, no, the whole legal system has to be adequate, not just in one sector like financial transactions or e-commerce.
Okay, thank you. Anybody else wants to comment on this specific point that Max raised? No? Okay, can we go to other questions? The gentleman there with glasses. Can you identify yourself, please?
Thank you. My name is Matthias Vermeulen. I'm a policy advisor to an MEP who is working on the Trade Committee. And
can you be louder, please?
Okay, my name is Matthias Vermeulen. I work for an MEP who is sitting on the Foreign Affairs, Trade and Human Rights Committee. And I would really like to have a bit of more thorough discussion on forced data localization measures. We were very interested in reading a study by Access Now in 2014, which basically said at the end as a conclusion, neither ensuring security nor privacy, the adoption of forced data localization measures could have a corrosive effect on human rights and the open global nature of the internet. And I was just wondering whether anybody on the panel would like to comment on that. Thank you.
Okay, so very good question. We haven't discussed localization, and there's a lot of discussion about that. US has proposed language, its language of that in TPP. Can you please comment? Who goes first? Joe?
Well, I'll say that our experience curve in 7 or 8 different countries that have localization requirements, and there are anecdotal examples that are beyond those 7 or 8, but those actually had formal legislation, not just somehow you had to localize, but there wasn't a formal legislative requirement to do so, does actually increase cost and create some of the limitations related to data flows and limitations related to global architectures. If you have 3 neighboring countries and you are required to have a data center in each of those neighboring countries, the economies of scope and scale that are beneficial start to go away. Now, if there is a requirement to maintain data for a certain reason, that might be justifiable. And it goes back to, I think, when you concept, you said privacy would always be a trade barrier. But the question is, the whole exception is about whether the trade barrier is justifiable. And the question is, in the countries where we are talking about, and they're not EU countries, where these things have happened, they are clearly predicated on driving business to the economy. They are clearly predicated on employment. They are not predicated on the protection of personal data. And it's that disguised barrier that becomes the problem where we are trying to deal with these, and those disguised barriers will lead to fragmentation on the internet, and that fragmentation is what could diminish the potential for cloud. I don't think privacy as a fundamental right is necessarily in any way in contravention of the ability to do cloud computing. Yes, we have to talk about how, we have to talk about burdens of implementation, and that goes to Jan's point about some of the soft questions that will be coming up as this, and they're not going to be easy questions. They're going to be hard questions. But I don't think there's an inherent tension. I mean, there might be an inherent tension, but there's not an inherent concept that these are not mutually achievable. But when you have these disguised barriers for the purpose of domestic economic benefit or national benefit to your domestic players, those then become the problems that create the trade dysfunction.
Okay, Rupert, you want to talk on this?
No, I think there were some very good points in what we just heard. We are having debates on this issue of localization, and believe me, there is no country in TiSA or anywhere else who doesn't have some sort of localization requirements, be it for national security, telecom, etc., etc. So you're coming back to the same problem. I mean, there is nothing to be said against reasonable, legitimate data localization requirements. Sometimes you can make your case, but there is also the question of a protectionist twinge here to help your server industry or whatever. And to divide these things is the real conundrum. It's not that there is a clear rule we should not have this, everybody has it in one form or the other, or we should allow it in all forms, which is absolutely detrimental to business as it works today. So we're back to the fine print.
Yeah.
I think that the most important first clarification which we need to have is that we are not talking about reducing the scope of the exemption of Article 14 when we are talking about data localization. And I think that's important to make that clear, that this would be also a complete no-go, because if you call a law which requires for safeguards for personal data to be transferred to another state as being a data localization law or requirement, then this is just not true. I really don't think that this is that this would be the right interpretation, and that needs to be clarified. I don't think this could be just left open for a later clarification. It needs to be clear from the beginning that data localization and the question which is reasonable or which is not reasonable doesn't touch on the question of the regulations on data protection and privacy rules also as a precondition and requirement for data transfers. I think that's a very important clarification. But then on data localization as such, I also think, as also it was said, there are many principles of data localization which might be perfectly fine and good. I mean, as there is, for example, the rule, I mean, in all states that normally authorities should be located in the state of the authority and not somewhere else, because you just have to otherwise really fear about the rule of law to be applied, you know. But if authorities are using cloud software, and all the information of these authorities are then stored outside of the jurisdiction, then of course we come already into a very vague environment. And therefore I think it's completely fine to also uphold the discretion to require localization of data. But it's a different thing to say, you have to put your data here while you are somewhere else, or if you say somebody who is here has to leave the data here. I think that's different qualities also.
Presumably, just to clarify for the audience, when we say localization, we are not talking about all the pipelines and things that go all over the world. We're talking about local processing and local servers in the final destination, yeah? Burcu, you wanted to comment briefly on that,
yes,
and then we'll go to the next question.
I'm going to be the devil's advocate here, so because we've been like...
We need a devil's advocate.
Yeah,
so
I'm going to be a devil's advocate. The thing is, like, I have serious problems with GATS 14, and as I told you, like, there were like 44 cases, like, including cases related to EC and US. And countries, they try to use this exception, they try to rely on this exception, because they believe that they are like public policy, the policy measures that they came up with, they satisfy the test. And I'm sure that there were lawyers there, or they check and they were like, yeah, we can rely on this exception. But they failed. They failed 43 times. There were only one case. That's the EC case that satisfy all, that passed all the tests, because it has, the exception has so many substats and too many qualifications. So it's really hard to pass the test. And at the end of the day, none of us would be in that arbitration tribunal. You know, when a company takes the country to an arbitration tribunal, none of us will be the arbitrators. Maybe you can be the arbitrator. You're a lawyer, so. Or none of us will be sitting at the WTO dispute board. So we can't really say that, like, oh, this will work, don't worry. You know, we need to be sure. We need to be sure that that exception will work for all these things that we've been discussing here.
So basically important points about transparency and private arbitration that can impact on this as well. Any other questions? Yes, please. Robin.
Hi, Anna, thank you. Robin Wilton from the Internet Society. There are two narratives underlying a lot of this, which I think often go unstated. And is that better? I'd be interested to know whether the panelists think that it's sufficient to call these hidden narratives out, or whether they also need to be challenged. The first one is an expression that people in the room may often have heard, which is regulation stifles innovation. And that underlies a lot of these points about, for example, data localization. Personally, I think that needs to be challenged, because I think the right kind of regulation actually stimulates innovation. But it's a question of which values you prioritize, and that's about the second of these hidden narratives. And that is, and not unexpectedly, because this is a discussion about trade, that economic activity is a good in its own right. And I very carefully say economic activity, not growth, because the barrier here is set very low. Economic activity is a good in its own right. Now, I happen to think that on this side of the Atlantic, we see economic activity as a qualified good, provided it leads to better social outcomes. So again, I wonder if the panel think it's okay just to call those hidden narratives out, or whether they actually need to be challenged as well. Thank you.
Thank you very much. Great question. Basically, two challenges to the panel. The first one, the narrative, the regulation stifles innovation. Second one, I believe, is that local storage and economic activity, economic activity is not necessarily an aim in itself. The aim in itself is the social good generally. Related to trade, please, yeah.
I'll take the first question. And I think the answer is, and this is I also went to law school, so the answer is it depends, which is a perfect lawyerly answer of no answer at all. No, I mean, the reason it depends is if regulation is overly prescriptive and overly detailed, then it will tend to stifle innovation. But if regulation is drafted correctly and forward-looking, it will actually facilitate innovation. And so the question is, how do we get to the point where we're optimizing as opposed to balancing? Because that's where the magic happens. Because you can get privacy right, you can get data flows right, and all of a sudden you're doing 1 + 1 = 3, and that's the new math. But if you're a zero-sum game, to quote Ann Cavoukian, you'll never actually make it out because it's a winner and a loser in all cases. And I don't think it has to be a winner and a loser, but it means we have to be open to the way in which we have the conversations, and that's where one of the exemption pieces to me is very important, which is this the least restrictive manner doing it? My theory is it has to be effective, but if you have multiple effective ways of doing stuff, the least restrictive is the one you want.
Okay, we've got 3 minutes left. Can I have final brief conclusions from the panel? Sorry, Robin. Yeah.
If you allow, I just answer the second part of the question. I have nothing to say on the first one. I think it was perfect. No, I think it's one of these misunderstandings that some of us in the trade world always fight about, that we're not here to do trade because we like trade. Trade is part of a bigger philosophy of sustainable development, and that doesn't mean trade is an end in itself. And that's in the EU treaty. That's in the EU treaty. Sorry, I forgot the quote.
If I were a lawyer advising the EU, I would certainly not give a positive rubber stamp to just relying on Article 14 of the GATS exemption as it stands right now. I would be a bad lawyer when I ignored that there are substantial risks to the interpretation and actual application of this rule.
Cam, two final words. We've got 2 minutes left.
So, on the question of trying through these mechanisms to deal with data and data protection, at least in a transatlantic context. As I said at the outset, I think that's hard enough in safe harbor without injecting it into trade deals. But I think the notion that we should develop the political will and a mechanism to improve interoperability between U.S. system and European system is, I think, a project of the future that needs to be undertaken.
Development. Okay, Burcu, 2 words, and Jan, you have the final word as usual.
There is no shortage of trade agreements. Let's not forget Trade in Services Agreement, TiSA. The same provisions also appear in TiSA because some of the TiSA chapters were leaked. So we know that these provisions, they've been proposed. But I think after this discussion, it becomes clear that we need to think about GATS 14 and start discussing how we can improve it.
Process. Jan, final words.
I think that it has to be perhaps noted that the European Parliament in its positions, as I said, already adopted and soon to be adopted on TTIP and TiSA. We didn't only refer to the GATS 14 exemption, but we said clearly that the respect to and the enforcement of the European data protection rules have to be untouched, and that needs to be assured based on a horizontal exception along the lines of Article 14 GATS. So we will have still a close look at the exact formulation of that exemption. And last but not least, I think that this is also always a debate about how acceptable is the framework which we built in the trade area on a global dimension for our citizens. And I think we need to deserve also some time to discuss that and to get to solutions which are sustainable for all sides.
Thank you very much to all the panel. Can we have a round of applause, please? And thank you to the audience.